Welcome to Floyd Zadkovich's video series. This is the second part of a two-part series. In this video, we're going to look at the facts of the English New Flamenco case and how those facts may be dealt with hypothetically in the US. So, under US law, the mitigation principles are much the same as they are in England. Indeed, you will find reference to many of the leading English authorities in the relevant US cases. The defendant has the burden to prove that the claimant has failed to take reasonable steps to mitigate its losses, or, in US terms, damages which the plaintiff might have avoided with reasonable effort are not caused by the defendant's wrong, and therefore are not to be charged against him. That's a quote from the case of Hess v. Dorada Tankerpool. So the US maritime cases do not address specifically the difference in kind issue we were discussing in the first video on this topic. The leading SMA New York arbitration cases deal with mitigation in breach of charter cases like we're talking about as an assessment in loss of earnings and what earnings may have been reasonably achievable in mitigation. They do not consider whether the innocent party could have sold the vessel in mitigation or brought that capital profit or the capital loss avoided into the loss of earnings equation. To me, that suggests a consistent approach with England. As an example, in 2003, there was a New York arbitration case called the Golden Gate. And in this arbitration, the arbitral panel, it held that owners acted reasonably in mitigating their loss of hire payments, in rechartering the vessel in slightly different trade, and even on terms with lower demurrage payments. Owners acted reasonably. That was the guiding principle. That's what the arbitrators were looking at. And really the key test in the mitigation analysis. What is interesting about this case is that there were three related contracts. There was a long-term time charter, a MOA for the purchase of the vessel by the charterers at the end of the charter, and third, there was a management agreement. Now, when charterers repudiated the time charter, they also pulled out of the ship purchase. So we had two breaches, two contracts, and the arbitrators had to assess damages. Now, what they decided to do was just to look at the two contracts separately, in effect. So they assessed damages separately for the sale contract and separately for the time charter. Indeed, the vessel was sold for scrap after the repudiation, which somewhat echoes the New Flamenco case, vessel being sold after repudiation. And the value earned in that scrap sale was brought to account in the damages calculations, but for the breach of the vessel sale and purchase contract. However, there was no suggestion that the loss of earnings from the time charter should be offset by the amounts recovered in the vessel sale. If anything, this distinction between the two types of claims and separate damages assessments reinforces the likelihood that a US court or arbitrator would follow the reasoning in the New Flamenco case. So in the Golden Gate case, the sale of the vessel for scrap was necessary as mitigation of the breach of the S&P contract and not the early termination of the time charter. To put it another way, the sale or the need to sell and therefore the benefit of the sale proceeds was contractually connected with the breach of the S&P contract and not the related time charter. I think it's also interesting in the Golden Gate decision that the arbitrators held that the correct time for assessing the value of the vessel was when she was due to be delivered at the end of the time charter and not at the time of breach, which is unlike the New Flamenco. So in this Golden Gate decision, the market value of vessels improved between the time of breach and the end of the charter. That is simultaneously with the time of delivery under the S&P contract. Again, this reaffirms that the arbitrators are looking to fairly assess the damages under the S&P contract by reference to the value of the vessel at the time that contract, the S&P contract, was to become effective, not the earlier time when the time charter was repudiated. This analysis or this treatment maintains the separation between the two types of claims, and it reinforces that a US arbitrator or court is unlikely to seek to consider the sale proceeds as mitigation of a time charter, unless, of course, they're causally connected. So this is only just a snapshot of how the US may hypothetically approach some of the issues thrown up by the new Flamenco decision, and particularly whether the resale of a vessel shortly after repudiation of a long-term time charter should be brought to bear in the damages calculations. I hope you've enjoyed this presentation. Please feel free to share it in your networks. We'd be very grateful. And let us know if you have any feedback on content, format, topics, anything that you would like to hear about. We'll try and put something together for you and post it on our website. Look forward to hearing from you. All the best, and thank you again for listening.